Good afternoon, everybody. I hope you all are comfortable. But don't get too comfortable because you have entered the finest and the noblest profession of this country. My heartiest congratulations to you all for becoming the lawyers and advocates. I would say you should all clap for yourself for this huge success in your life, ladies and gentlemen. Today I have been asked to deliver a lecture in the memory of Dr. B.N. Rao, who is one of the finest legal luminaries of this country. He has been the right hand in the Constituent Assembly. For 3 years, the worthy Constituent Assembly worked the stupendous task of upholding the principles of constitutionalism, and it was able to achieve for all of us the way we are sitting today, that there is no lawlessness, there is the rule of the law. So this year marks the 75th year of our Constitution, which was finally approved by the Constituent Assembly and adopted with all favor and enthusiasm on 26th of November 1949. Some of the provisions came to the force on that day itself. And on 26th November now we celebrate, as you know, as the Constitution Day. The vast majority of the provisions of the Constitution, they came force on 26th of January 1950. This part you all already know. Now, when we talk about the Constitution, we must realize why law came into the existence, why you all are important, why the society should care about you. That is the first and foremost principle that requires consideration from you all. You call yourself lawyers, crusaders of the Constitution, officers of the court. But what is it that defines you and gives you that X factor from the other individuals? Why is it said there is a lawman and there's a layman? Why do you fall under the category of lawman and not layman? It is not just the LLB which defines you. But rather, I would say, if you go back to the basics during the times in Ramayana and Mahabharata, you all must have heard from your grandparents, parents, or by reading these scriptures that सूर्यास्त के टाइम पे कोई लड़ाई नहीं होती थी. Everybody, they halted their weapons. If you all can recall. Second of all, there was a custom that the river from which the water is commonly shared between both the sides at the battleground, that is not poisoned. These were certain customs and traditions that empowered the legal aspect, and that is how the laws were involved. They became customs, customs became laws, laws became rules, regulations, and your so-called now bare acts, which you all interpret before the courts of law. So these laws, they have evolved with the passage of time, and the evolution, we cannot change the word change itself, right? Every time we hear this one particular line, one time or the other, you all must have heard, you all legal luminaries must have heard, that law is dynamic and change is constant. So when the society has changed its traditions, its customs, its way of thinking, the legal system has also changed, sometimes slowly, sometimes drastically, sometimes speedily, but the change has always remained constant, in my humble opinion. With the permission of you all young lawyers now, I congratulate you. I would like to mark this moment by first discussing what is the basic gist of constitutionalism. So it's a heavy word, of course, first of all, but we all are deeply affected by it. I will give you an example. The 101st Amendment of the Constitution of India took place, which brought into force in 2016-17 the goods and services taxes. Now, of course, it has deeply affected you largely in your lifestyles, in your rules, regulations, in your day-to-day well-being. That is the locus and power of law. And the object of a written constitution, if I talk about, in a democracy are broadly threefold. First, to establish the framework or structure of the government. Second, to delegate or assign powers to various organs of the government. There is legislature, executive and judiciary. We all have learnt it in law schools. And much prior in maybe 7th or 6th class in civics or political science, we all must have heard about it. And third, the most important, where you come into the picture, is to restrain the exercise of those powers which are arbitrarily done and imposed upon the individuals, the citizens, the non citizens, where their rights, fundamental duties are breached. When I say rights, I mean both fundamental rights and legal rights, statutory rights. For example, I may enter into a contract with this gentleman here, young and dynamic, that I have to provide certain goods or services to him. And if I don't honor my contract, the law comes to the rescue, and that law is the Indian Contract Act, which was established much prior in 1873, ladies and gentlemen. So, law comes to your rescue and provides the agendas on the table, which gives you bread and butter as well. That is why you all are lawyers. So, when I talk about the Constitution of India, please remember and be proud of yourself for the fact that the Constitution of India is one of the most comprehensive and well drafted, spirited document, and it has become one of the finest creations of the legal side in this country. It deeply affects you, and our constitution, it represents high watermark of consensus of India's political history. It is the constitution which had the era of emergency. It is because of the provisions in the constitution. It is the constitution which had replaced certain words, which caused more clearance of ambiguity within the minds that where is India heading? Where are we all going? It is the Constitution which is the supreme document on the basis of which the President of this country, the Prime Minister of this country, the Chief Minister, the officials of the government, they are all thoroughly appointed. And they can be impeached as well through a process which is the Constitution. So, at the verge of 75 years of the coming into force of the Constitution, I want to first congratulate you all that we are part and a symbiotic system of this syndicate that has been formed because of the Constitution. And Dr. B.N. Rao, many have remembered him, many have forgotten him, but let me tell you, he has had a deep impact in all of your lives. Because Dr. Rao was not only a legal luminary, he was a genius who was second in command along with Dr. B.R. Ambedkar to ensure that the constitutionalism and the principles, they are enunciated and they come into force effectively, properly, without any ambiguities. Suppose even one comma is missing, the meaning of the whole word changes, right? That is what is the job of the Constituent Assembly, and that is how he, if I talk about his credentials, I cannot be prouder enough to say that once one of the legal luminaries, Justice Frankfurter, he was saying something about Justice Rao. He's a very big legal luminary of his times. He said, and I quote, "If the President of USA were to ask me to recommend a judge for our Supreme Court on the strength of his knowledge of the history and working of the American Constitution, Dr. B.N. Rao would be the first on my list." He was a civil servant. He was a retired High Court judge. He worked for the bar and the bench and for the country. He passed away in 1953. 1950, the Constitution came into force, but before he passed away, he was appointed as the judge with the Honorable International Court of Justice in Hague, where he brought laurels to this country and represented India globally on the constitutional side. Ladies and gentlemen, when we talk about the Constitution, we also should talk about the evolution, how the Constitution of India has evolved over the time. What is it that has distinguished our Constitution from any other constitution of any other country? First and foremost, I would like to mention to you all that the fundamental rights, which is the heart and soul of the Constitution, They have been thoroughly protected by the Honorable Supreme Court, the Honorable High Courts, and all the other courts across this country. And in the first 15 years, ladies and gentlemen, the Supreme Court may be characterized as a conservative era. We didn't know what to do. The Constitution had just come into force. However, the court, while giving deference to legislative wisdom, acted firmly in various areas of striking down the impermissible legislations. But that was mainly in the era of fundamental rights relating to property, agrarian reforms, trade, business. We came up with the principles of reasonable restriction, reasonable classification. You must have heard these principles and studied them in your academics while being a law student. It has been rightly said that in its initial years, the court was manned by a band of erudite and dedicated judges, who in the case before them granted a disciplined and learned debate free from bias and acrimony. Judicial power in their hands did not foreclose the future. The doors were closed often but not bolted. And the judgments of that era set the tone of direction along with which subsequent journeys had laid the strong foundation of the legal future and the political future of this country. The Supreme Court, the Honorable Supreme Court, has taken great strides in developing the constitutional law in this country. The great theme in our history of our constitutional law is the concept of law itself, as the checks and balances upon the public power prevail. It is the Constitution which brought the principles of accountability, because of which further principles, since in 2005 the Right to Information Act came. It is all happening because of the principles enunciated in the Constitution. And natural justice is a law which came on its own. During the times of Raja Maharaja also, it was there that there were no advocates, but there were learned, distinguished persons who would take up briefs of persons to present their case. That is how advocacy started. Then the general rule was, let the person be heard before he is punished. The principles of audi alteram partem, you all must have heard, that comes from there. And the distinction between administrative law and quasi-judicial powers was also obliterated. The right of being heard was held to be an essential requirement. The doctrine of promissory estoppel, you must have heard. That was placed the firm foundation. There were many litigation cases like the Royappa case, Menka Gandhi case on the passport, you all must have heard about it. Mohinder Singh Gill case, and R.D. Shetty versus Airport Authority of India, you must have heard of this case. You must have written this pen down in your law school exams. This is one of the first 2-3 cases you write to score marks. What does that case say? It talks about the definition of Article 12. Article 12 of the Constitution of India defines state. Who can be susceptible to be called as a state to take checks and balances against them? Whether a simple association of persons can be a state, whether a company is a state, whether a public limited company comes under state. All these questions, they have been answered by the Honorable Supreme Court. I will not get into the depth of that, but that is one. Then came the legal principles in the famous breathtaking case of His Highness Keshwananda Bharti. Keshwananda Bharti, you must have heard of this matter. While any other constitution may be amended, the amendment should not be able to abrogate the basic essential principles of the Constitution. This is what the judgment says. It is a 1,000+ page judgment, but that is the basic gist of this judgment. It saved and rescued the Constitution from the legislators as well, that tomorrow they may not come up with some amendments which changes the basic face of the Constitution only, on the basis of which the principles of fairness, equity and good conscience were prevailed, right from the preamble to all the articles of the Constitution. And the idea behind the basic structure doctrine, my friends, my legal luminaries, is to ensure that by the process of amendment, the Constitution is not denuded of its core or essential values, and its sanctity is not lost. Therefore, it is very important for you in your day-to-day lives that is how the Constitution came into force and protected. The march of science and technology, I would like to say, has an interplay of economics, social sciences, law, politics, and influence. It has created the influence on the existing political and legal institutions, and it cannot be overlooked. All this throws up newer challenges and offers more creative probabilities for judicial review. Time and again, the Honorable Supreme Court, the Honorable writ courts of this country. How many of you know which are the writ courts of this country? Can anybody say? Yes, that's correct. High Court is the writ court of this country, and there are wider powers under Article 32 also with the Supreme Court of India. It has unbridled powers as well. So, this calls for a robust and balanced exercise for the power of judicial review in fulfilling the obligations of the trustees of an enlarged government. The Constitution has to be judiciously and wisely worked in order to realize the constitutional vision of justice and to ensure that it remains workable in a broader sense. This requires applying unchanging constitutional principles to changing circumstances to meet from time to time the altering conditions of a changing world with its shifting emphasis and different needs. And we live in a country where we have been blessed by great judges, jurists, some who have dissented also in some controversial judgments. The talk of the town, those landmark judgments. But we must remember that as lawyers also, you do not have to go with the generic opinion. You may have your own opinion, formulate your own opinion rather. It is to be remembered that even dissenting judgments can be landmarks and provide an impetus. It provides a vision. Maybe the country was not ready for that particular part of the dissent at that point of time. But now that dissent becomes the majority judgment. We have seen it in many cases. It does happen. And I would rather say a dissent is an appeal to the broadening spirit of law, to the intelligence of the future day. It is an appeal not only to the intelligence of a future day, but it is also sometimes a call to and a grounding in the traditions and the wisdom of the past ages rendered by experience and wisdom and discernment. So, this was the first part of my lecture, which is divided into 3 parts. I wanted to talk to you about the principles of constitution and constitutionalism and why it is imperative for you all to understand the nuances of the constitution. The second side of it is, which I will fail as a speaker if I don't talk to you young lawyers heart to heart about how we are going to proceed about it. There is a classic question. My associate is just standing here. He asked me when he joined the profession, which you ask yourself, Sir, अब मेरा क्या होगा? अब क्या करना है? कैसे होगा? There are thousands of lawyers in this country, lakhs of lawyers. There are thousands of cases ongoing. Why somebody should bother or care to refer you any brief, should mark you any brief and bestow upon you that responsibility and trust that you will deliver results? That is the classic question that comes to any person's mind. When I see you all, I see myself sitting there in the same room and thinking about the same nuances. What will happen to me? Will I fail? Will I flunk? What should I do? What will my family say? What will my friends say? It's been so many years, suppose. What have you done? So these things come into the mind of a lawyer, but let me tell you, law is like a jealous mistress. You have to pay homage to it. It is requirement of the profession that you need to give your heart and soul and put in the maximum effort. Without it, mediocrity will come into picture. things will be average, income will be less. But seeing your faces, I only see positivity. I see many parents who are here to support their children, who have spent hard earned money to ensure that their child becomes a full fledged lawyer, which comes to be a noble profession. So, what are the few learnings I have had in my legal career as a lawyer so far? That some mistakes made me learn, some I learned from the mistakes my seniors made, some while sitting in the court I heard and I learned from them, some I keep learning and I will continue to. One of such situations is the right attitude. To become a lawyer means you should need to have a right attitude. And this principle applies even for those who are going to sit on the bench one day. Many of you will be selected in the state judicial services. Some of you will be first junior counsels, then lawyers, then senior designates, and then will preside the bench. But the principle remains the same. And that principle is to be true to yourself. My grandfather used to say, may his soul rest in peace, the biggest fall in one's eyes is, the biggest fall for one person is the fall in his own eyes. अपनी नज़रों में नहीं गिरना है. You have to think big, you have to be positive, and that is how that will make a dent on the universe and you will make a mark. I'm using strong words here. It is easier said than done, right? But there is one thing I would like to pass on, that is consistency, which makes or breaks you. If you are consistent enough every day with the small learning, you may read one section, one article, one regulation, one rule of that bare act. But that may be so, you read it so thoroughly that it creates an impact for you. You are thorough with it. That is the first learning. Second of all, these learnings are divided into three parts. First is with the judges. Need I say that when you are addressing an honorable bench, you need to be very courteous and you need to ensure that the language you are using is proper and parliamentary. Some of you got the privilege to argue in moot courts nationally, internationally, district-wise, state-wise. Some were part of the mandatory moot court competition. Some could not even attend that, but don't worry. You all are on the same footing. That footing is you all are eager to learn and grow. That is what makes you true individuals who are willing and ready to fly. So, in the courts, please remember, my young legal friends, or younger as I should say, mobile phones usage is very tempting. You use your phones in the courts, like I am standing here. A gentleman or a gentle lady would be sitting and observing you in the court. This is like a courtroom, right? The podium is higher, everybody is visible. So please ensure you maintain the decorum of the court. Do not use mobile phones so recklessly. Of course, if you are using it to check the display board of your case, suppose you are in the High Court or any tribunal, that is good. If you are practicing in the Sessions Court or the Magisterial Courts or before a civil judge, have the courtesy and decency not to pick up a phone call of your near and dear ones or clients during the courtroom premise. Go outside and take that call. Put your phones on silent, on vibrate. Your clients will respect you more if you are available to them at the right time. If you are available all the time, they are not going to respect you. You need to draw a line. And one more important thing which we often forget is, being a young lawyer, which I have learned over the passage of time, that when you start the profession, suppose you read a case law, your senior or your own individual brief, you are asked by the client or your senior to argue the brief. So you go to the court excited, today I'll argue, either you are nervous or too excited. And in that enthusiasm, positive or negative, sometimes we fumble the basic gist, which is understanding that the query of the bench needs to be addressed and answered immediately. Hear the judge, hear the honorable bench. What query are they asking? They may be saying something in your favor, and by being excited, you are maybe causing annoyance to them, which will be a heavy cost on your client. Don't do that. Thirdly, the politeness in the court is very important. Learn to be sophisticated and polite personalities in life now. You are lawyers. There is an instance that, or generally if we say, any person does not like to go to a court or hospital. Isn't that true? So you are the last person anybody wants to talk to. But it is also true that you need a lawyer until you need a lawyer. So you always need a lawyer. So for this reason, you need to ensure that some empathy and compassion is also there within you. Somebody has come to you, maybe for his pension matter, his bail application, his property has been illegally occupied, maybe his ex-wife is troubling him. It is the world to them. You need to ensure as lawyers that you don't mess it up, and you are able to take this further by working hard. Hard work comes from what? Preparation. Preparation starts the day one the client is narrating the facts to you. Please use a pen and paper. Always keep one in your coats, in your pockets, a notepad maybe. Always have pen, paper handy with you. You never know something important somebody says to you. It can also happen in the courtroom. Suppose one lawyer is arguing, this gentleman is arguing, and this lady here, she feels this judgment is applicable to my case. If she doesn't write it down, this is all going to waste, because 5 days later you're not going to remember the case title. Please ensure that. And answer the queries of the honorable bench. Be balanced, be precise, be quick. Balanced, precise, and quick. All three things come from only one term: preparation. Prepare your briefs thoroughly. They say that facts of the case may or may not be important, especially in the higher courts, but I say 90% of your case is mastery of the facts. You are the captains of your own ship, and that ship is your brief, my friends, which you have taken with utmost sincerity and responsibility as legal individuals, and you wish to now accomplish victory for your client. Right or wrong, your client is, I'm not getting into those depths and details. One side is always right, one is always wrong. But your effort should be so massively done that tomorrow, whether you win the case or lose the case, the client comes and tells you, sir, ma'am, आपने बहुत मेहनत करी इस केस में. Be that lawyer. The client should know you are hardworking. Which takes me to the second. The vis-a-vis the colleagues. You all are sitting together, but you often will join some law offices. Some of you will join corporates, but you all will remain colleagues, right? So as colleagues in the courtroom, I would say, the basic principle is you have to be respectful to the colleague who is also a preparing lawyer. Suppose I am unwell and I am unable to take the brief today to the court and argue the matter. It is my duty and responsibility as a lawyer to inform the opposite counsel I am unwell and therefore I won't be able to come. I am going to send some of my associate, my friend, my brother, somebody, some advocate who is going to take care of the situation. Be courteous. Second, always ensure the judgments you rely upon in the courts, whether it is right from the municipal courts to the highest court of the country, the Honorable Supreme Court. Be decent enough to share the judgment you are relying upon. Often lawyers make one copy of the judgment, they forget due to paucity of time, nervousness, and they give directly to the honorable bench. The bench asks, what is the relevant paragraph in this? Please say. but you don't remember because you have only one copy. I'm not saying have one copy only. Have a second one for yourself and a third one. Third one also for the opposite counsel. Suppose there are many opposite counsels, have similar number of copies for them. If you are going to rely upon that case law, your preparation should be so much, you should be so confident that it should not matter to you whether you are passing on your Ramband, that is your judgment, to the opposite side. You should be so confident and thorough with the facts and law. That is my 2 cents on this. Then, always be helpful to your colleagues. It is these colleagues only, some may become judicial aspirants and vice versa in different fields. Some of you will join litigation, some of you might not join litigation. Some of you might join in-house counsels, some of you might join some companies as the law officers or some public undertaking companies, PSUs. But remember, each one of you symbiotically needs the other. We all are together relevant and prevalent together. This needs to be understood. Without helping your colleague, you are depreciating your credibility. ये मत सोचिए कि मैं क्यों बताऊं उसको ये जजमेंट, मैं ये ड्राफ्ट क्यों भेजूं, ये फॉर्मेट क्यों भेजूं. आप अपना एफर्ट करिए. Get rid of the insecurities. There will be a time that particular colleague is going to call you up and collaborate with you. It has happened with me before, I'm telling you. Be that kind of lawyer. Be the lawyer you would want to hire. That is the principle I always believe. कि आपका खुद का मुकदमा लगा हो, चाहे 10 रुपए की चीज हो या 10,000 करोड़ की चीज हो, मुकदमा होता है, उसको प्रॉपरली लड़ना बहुत जरूरी है. That is one thing I would like to point out. Then when it comes to clients, I would also want to share one experience with you. Clients these days are very, I won't use the word clever, but diligent. Always tell the true things to the clients. What often many lawyers don't do, which you can do, being the technological enthusiasts also, you all know how to mail and greet and write letters. Please inform your clients electronically of the dates of the case. Any draft you are making, even if it's a small application, send it to the client. And always remember that it is this profession which is your now bread and butter. Be true and honest to yourself, and I wish you all the best, and especially focus on the new aspects of law, that is artificial intelligence. Don't rely heavily on ChatGPT. Use alternate dispute resolutions as a method and mechanism to resolve your client's disputes. You come out as a better lawyer if your client's disputes are resolved much before the courts are coming into picture. And the day you lose faith in yourself is the day you lose your case, my friends. So don't lose the faith in yourselves and become better and prominent, distinguished lawyers. And I wish you all the best. Thank you so much. And don't be afraid to ask questions. If you have one, just shoot it right away. Anybody? Any question? All right, thank you so much. It's a pleasure to address this esteemed gathering of young and dynamic lawyers. Thank you so much.